All right, welcome to another deep dive where we take your submitted sources and pull out all the most interesting bits and try to make sense of it all for you.
And I think today's is going to be particularly fun because we're looking at a fascinating historical case, a legal one.
Yeah, I mean, when you said we were going to be talking about contract law, I thought, oh boy, but this is way more interesting than I was expecting.
Definitely. It's Carlill v. Carbolic Smoke Ball Company, and it's from 1893.
1893, wow.
And you sent us the court records of the appeal itself, which is great because we can really get into the nitty-gritty of the arguments.
So for this deep dive, our mission is to understand the core elements of contract law that this case illustrates and why it's still relevant.
Exactly. And I think what's really going to grab people's attention is just how unusual the situation is.
Yeah, it's not your everyday legal battle. I mean, we're talking about a company that promised a reward to anyone who got sick after using their product.
Yeah, you don't see that every day. And there's some surprisingly important legal arguments involved that we'll get into.
All right, so let's set the scene first. What exactly was this Carbolic Smoke Ball, and what was this famous advertisement all about?
So the Carbolic Smoke Ball was this device, and they marketed it as a way to prevent influenza and other colds. And their advertisement was really something else. They promised a £100 reward.
Wow, £100 back then? That's...
Oh, yeah, a huge sum, a small fortune. And they promised this to anyone who got sick with influenza or a cold or any kind of cold-related illness after using their smoke ball.
Wait, so you use their product as directed, and if you still get sick, you get a reward?
Exactly. That's what they claim. You have to use it 3 times a day for 2 weeks following the printed instructions.
That's pretty bold. It's like they were almost inviting people to get sick.
Right, and you would think that would make it seem like a bit of a joke, just a marketing ploy.
Yeah, like who would take that seriously?
But there was this detail in the advertisement that really stood out to the court and made them take it seriously.
What was that?
They actually said that they had deposited £1,000 with the Alliance Bank just to show how sincere they were.
Oh, so they put their money where their mouth was.
Exactly. And one of the judges, Lord Justice Lindley, he dismissed the arguments that this was just like a policy or a bet.
Because there are people saying that, right?
Oh, yeah, some people tried to argue that, but he pointed to the advertisement itself and said it had nothing whatever in common with a bet.
So the court was pretty clear that they saw this as a serious promise.
Absolutely. And Lindley LJ specifically called it an express promise.
Meaning
it was a clear and definite statement, not just some vague marketing fluff.
He used pretty strong language too, didn't he?
Oh, yeah. He said, here is a distinct promise expressed in language which is perfectly unmistakable. So there was no doubt in their minds that the company meant to be bound by this offer.
And that bank deposit really sealed the deal, didn't it?
It did. It showed they weren't just making empty promises. This wasn't just what they called a mere puff, which is basically just exaggerated marketing talk that no one's really expected to believe.
So they had made a promise and they seemed serious about it, but how did this become a contract with someone like Mrs. Carlill? That's where offer and acceptance come in, right?
Exactly. So the court saw this advertisement as an offer to the world at large. Anyone could accept it.
So it wasn't directed at any one person specifically.
Right. It was a general offer. And the way Mrs. Carlill accepted it was by doing exactly what the advertisement said.
She bought the smoke ball and used it 3 times a day for 2 weeks.
Exactly. And the court said that by performing the conditions of the offer, that was her acceptance.
So she didn't have to write a letter saying, I accept your offer or anything like that?
Nope. Her actions spoke louder than words in this case. And there's actually legal precedent for this kind of thing. The case of Williams v. Carverdine was similar. It involved a reward for information.
And in that case, too, they said that performing the action was enough to accept the offer.
Exactly. And Lord Justice Lindley even referenced another case, Brogdon v. Metropolitan Rye-Coey, where Lord Blackburn said that notification of acceptance doesn't always have to come before the action is performed.
So you don't have to say, I accept, before you go and do the thing they're asking you to do.
Right. And in this case, the company was basically saying, we'll know you've accepted our offer when you come forward, having used the product and still gotten sick.
That makes sense. It's kind of like finding a lost dog. You don't call the owner beforehand and say, I accept your reward offer. I'm going to go look for your dog now.
Exactly. You just go find the dog, and that's your acceptance.
Now, I know the company tried to argue that the advertisement was too vague to be a real offer. What did they say specifically?
Well, one of their main points was that there was no time limit on when someone had to get sick after using the smoke ball.
Yeah, I mean, you can't expect them to be liable forever if someone gets the flu 10 years later.
That's what they were saying.
Yeah.
And the court actually agreed that they couldn't be held liable indefinitely.
So how did they resolve that?
Lord Justice Lindley said that the offer could be interpreted in a couple of ways. Either you had to get sick during the current influenza epidemic or within a reasonable time after using the smoke ball.
Okay, but what does a reasonable time even mean?
Well, the court said that could be determined by looking at things like expert opinions. They even mentioned the possibility of consulting a chemist about the smoke ball's ingredients.
And asking a doctor how long the protection should last.
Exactly.
Yeah.
So while there wasn't a precise timeline, the court said it was clear enough to be a valid offer.
All right, now there's another big piece of contract law that comes into play here. Consideration. Can you explain what that means?
Sure, so consideration is basically what each party brings to the table in a contract. It can be a benefit for one side or a detriment or inconvenience for the other.
So like in a simple sale of goods, the buyer gives money and the seller gives the product.
Yeah, exactly. And the Carbolic Smoke Ball Company argued that Mrs. Carlill hadn't actually given them any consideration.
Really? How did they figure that?
They said they only benefited from selling the smoke ball, not from her actually using it.
So what if someone just found a discarded smoke ball and used that? Would that count as consideration?
That was their argument, but the court didn't buy it. They had a couple of counter-arguments. The first was that the company clearly wanted people to use the smoke ball.
Right, because they thought that would lead to more sales.
Exactly. More people using it would mean more people buying it, and that's a benefit for the company.
So her using the product was part of their business strategy.
Right. And the court also said that Mrs. Carlill had actually experienced an inconvenience by using the smoke ball 3 times a day for 2 weeks.
It must have been annoying to do that.
That's what they were getting. They called it a detriment, and they said that was enough to be considered consideration.
So whether it was the benefit to the company or the inconvenience to Mrs. Carlill, the court said there was consideration.
Exactly. And the company actually tried to use another case, Gerhardt v. Bates, to support their argument, but the court said it wasn't relevant. Because in Gerhardt v. Bates, the person suing hadn't shown that the promise was made to them specifically.
So there was no connection between them and the person making the promise?
Right, whereas in this case, the offer was clearly directed at anyone who used the product, and Mrs. Carlill definitely did that.
All right, so the company also made the argument that you can't have a contract with the whole world. How did the court address that?
Lord Justice Bowen was very clear about that. He said that while the offer was made to the world at large, the contract only happens when someone actually performs the conditions.
So anyone can see the offer, but you only enter into a contract if you actually do what they're asking.
Exactly, and he used the example of a reward for a lost item.
Yeah.
The offer is public, but the contract is only with the person who finds the item.
And he distinguished that from like a regular advertisement for something in a store, right?
Exactly. Those are just invitations to negotiate, not actual offers to form a contract.
So there's a difference between saying, I have this for sale, and I'll give you a reward if you do this.
Right, and we talked about notification of acceptance before, but there's another point to make about that.
What's that?
Usually you have to tell someone you accept their offer to make a contract.
Yeah, that makes sense.
But Lord Justice Bowen said there's an exception to the stay, that the person making the offer can say or imply that they don't need formal notification.
And they did that in this case, right?
Exactly. The way they phrased the advertisement implied that they didn't need someone to say, I accept your offer, before using the smoke ball.
It's like that lost dog example again. You don't have to tell the owner you're going to look for their dog before you actually start looking.
Exactly. And then one of the other judges, Lord Justice A.L. Smith, he also talked about consideration and what it meant in this case.
What did he say?
He agreed with the other judges, and he focused on the inconvenience to Mrs. Carlill from using the smoke ball and the financial benefit to the company from people using their product.
So those are the two main things that made up the consideration in his view.
Exactly. And he said both of those things were enough to make the promise legally binding.
So after all that back and forth, what was the final decision?
The court sided with Mrs. Carlill. They said the company had made a binding promise and she had fulfilled the conditions, so she deserved the reward.
So what are the big takeaways from all of this for our listeners?
Well, first of all, this case shows us the main elements of contract law: offer, acceptance, and consideration.
And those are all essential for a contract to be valid.
Exactly. And another important point is that companies can be held to the promises they make in their advertising.
Which wasn't always a given back then.
Right. And that's why this case is still so important today.
Yeah, it really set a precedent for truth in advertising.
Absolutely. And the thing that really struck me is that a simple advertisement can actually create a legal obligation.
If it has a clear promise and shows intent to be bound, and invites acceptance through actions.
Exactly, and that bank deposit really showed they were serious.
It did, and it makes you wonder how advertising has changed since then. Companies are a lot more careful about their wording now.
I'd imagine so, and especially with social media and things going viral so quickly, there's even more potential for companies to get into trouble.
Yeah, you've got to be careful what you promise these days.
So for all of you listening, think about the ads you see every day and whether they could actually be considered contracts.
You never know, you might be entitled to some kind of reward.
And if you come across any interesting cases like this, be sure to send them our way for a future deep dive.
We love getting your suggestions, so keep them coming, and thanks for joining us on this fascinating journey into the world of contract law.
It was a pleasure.